Thank you for taking time out of your evening to come to the first installment of the 2012 Wilderness Issues Lecture Series. And every year we try to line up a different topic with a set of speakers from all over the country to talk about that specific topic. This is my first time running the series. This is my first year working for the Wilderness Institute. And this year I chose the topic of water. Our entire lecture series is going to focus very broadly on this topic. Our opening speaker tonight is Joe Hopenkotter, who's a staff attorney with the Confederated Salish and Kootenai tribes. Our next speaker next week will be Aaron Wolf, who's a professor from Oregon State University in the Geosciences program. You can find the entire schedule for this series on the Wilderness Institute website, the College of Forestry at the University of Montana. If you have any questions, you can contact me directly at the Wilderness Institute as well. Our number is easy to find on the web. Joe Hopenkotter is here with us tonight. He's an attorney who represents the Confederated Salish and Kootenai tribes on issues related to energy, environment, natural resources, real property, and transportation. Joe grew up in farm country and spent many hours as a kid messing around in the Tanum Creek, and it's related to irrigation ditches in the west edge of the Yakima Valley in central Washington. So he has a connection to water, which is what we're looking for with all of our speakers. He attended Central Washington University as an undergraduate where he obtained degrees in biological sciences and secondary education. He then worked for a short stint as a field biologist for the U.S. Forest Service before taking on his first career as a math and science teacher in secondary schools in Washington, Idaho, and Japan. After teaching for 6 years, Joe found his way here to Missoula, where he earned a JD at the University of Montana School of Law. Joe started working with the Confederated Salish and Kootenai tribes as an intern in 1992, and has stayed with them as an attorney ever since. His primary tasks for the tribes have been to litigate and negotiate the tribe's Clark Fork natural resource damage claims, negotiate details of the U.S. Highway 93 reconstruction project, negotiate renewal of highway, pipeline, and electrical transmission line rights of way with utilities and state agencies, litigate and negotiate the tribe's environmental mitigation claims related to the Kerr Hydroelectric power project, and assist the tribes in preparing to acquire, own, and operate the Kerr hydropower project starting in 2015. This evening, he's going to talk about many of these projects that he's involved with right now. He will provide us information regarding Indian tribal rights, with regard to Western U.S. rivers in 5 parts, including Indian treaty fishing rights, tribal participation in Clark Fork River remediation and restoration, Confederated Salish and Kootenai tribes' interest in the Flathead River hydroelectric projects, primarily the Kerr project as mentioned before, the American Indian tribes and the Canadian First Nations' interest in the Columbia River Treaty, and then a summary of Indian water rights. So we've got a lot to talk about this evening. Let's go ahead and welcome Joe to our forum.
Is the sound about right? It's okay in the back? Okay. First, some housekeeping. There's an outline that's circulated. The outline's mine that I prepared. It parallels the PowerPoint that you'll have here. So the substance is the same. As a former teacher for a while, I understand that fear is a powerful motivator, so I don't know if this is part of the assignment or not, but you don't have the actual PowerPoint in print form, but the substance, like I say, is exactly the same in the Word document. Second, I'm an attorney, so I'll start with the disclaimer, of course. Even though I work for the tribes as a staff attorney, I'm not here in an official capacity tonight. I'm here on my own, so the materials that you have are materials that I produced, basically, and they're not materials of the tribes specifically. If you have questions about them, please feel free to contact me, but please don't take them as any sort of official statement from the Confederated Salish and Kootenai tribes, because they are not that. Third would be, I guess, why somebody from an Indian tribal government who would come and talk about rivers, and I think the answer is pretty simple, and that's that Indian interests are ubiquitous in rivers in the West. And you'll see that somewhat as we go through it tonight. And lastly, maybe in housekeeping, I try to give you some sense on where the 5 topics came from. They're a little disparate, but what I tried to do as I was thinking about what I might talk about was to step back and say, if I were coming to work in western Montana or somewhere in the west, and I were going to work on a river system, what would I want to know about Indian tribal interests? And that can be pretty dry, particularly if you're getting it from a lawyer, because you could get 5 to 30-point outlines identifying what the state of the law is and what the state of the various court opinions are for interpreting the law. What I tried to do here was identify 5 areas of law that if you were working in western Montana, you would encounter, and you definitely would encounter tribes. And I tried to provide some law to go with it, and then also put a little bit of pizzazz to it, so it wasn't just a straight-on lawyer's summary. So that's what you got. Any questions before I start? Initially, I think it helps if you get a little bit of context about my employer. So slide, please. The Confederated Salish and Kootenai tribes are a confederation. They're an Indian tribal government recognized by the United States. They're formed from 3 Aboriginal tribes, the Salish and Ponderay, both of which were Salish-speaking tribes, and the Kootenai. And it's one amongst 8 bands of Kootenai that speaks an entirely different language from the other 2 bands, and they have a very unique language worldwide, actually. So this was not a natural confederation. It was a confederation that was put together somewhat unnaturally, and we'll come back to that as we carry on. Their Aboriginal territory included much of what we refer to now as the Northern Rockies. It included parts of the provinces of Alberta, British Columbia, and states of Idaho, Montana, Washington, and Wyoming. And they would have even gone further than that. But as far as talking about it with certainty, those jurisdictions would have been areas where they were. Then if you talk about the areas that were formally recognized as their areas of Aboriginal territory where they have legal rights, you'll hear me refer sometimes to ceded territory, and that refers to the territory that they ceded to the United States by terms of the treaty that they negotiated with the United States. So generally, Aboriginal territory and ceded territory are similar. Ceded territory is a legal representation of the exact areas that the tribes can claim as their Aboriginal territory. The tribes are a big outfit. They have about 7,500 members. They have a headquarters in Pablo, Montana. Their reservation is about 1.3 million acres. And they have an annual budget of about $105 million. To give you some sense of scale, that's about 6% of the budget of the state of Montana. So it's significant, particularly for the small area of western Montana where their reservation is located. They have about 1,800 employees. 1,200 of those are full-time that work in western Montana and other areas throughout the country. And there's 600 of them that are temporary and seasonal, and they're all here in Montana. The tribes have about 30 agencies within their government, and they're doing a wide variety of things. I won't try to list them all out. You can kind of see by reading through the list, but they are doing everything a government does with regard to trying to provide law and order, security, education, and many other things. The one thing they don't do is national security. Otherwise, they're very much equivalent to any other local or state government. Their organic laws, if you're looking to try to figure out what tribes' rights are, for the most part, tribes were formed either by treaty or by executive order. So you're going to look at executive documents for that. In this case, with the Confederated Salish and Kootenai tribes, they signed 2 treaties. One was the Treaty of Hellgate that they signed in July of 1855, right here at Council Groves, just downriver a bit. And the second was a treaty that they signed in October after they had some disagreements with the Blackfeet about their rights to continue to travel after they'd entered into the first treaty. They signed a second one that secured to them the continued right to travel to the Yellowstone River and the Yellowstone River Basin to take bison and do some other usufructuary or gathering sorts of activities. Then the one critical federal piece of legislation is the Indian Reorganization Act in 1934. It was the act by which the United States provided for formal representation of tribes and formal organization of tribes. The Confederated Salish and Kootenai tribes were the first tribes in the nation to go forward and secure a constitution in 1935 from the United States. And simultaneously with that, they also secured a corporate charter from the United States, chartered pursuant to federal law. The United States recognized that tribes, in addition to being governments, were going to exist inside state jurisdictions that were very unfriendly to them. And for them to go forward, because they lacked general power of taxation, they might not have sufficient resources or assets to conduct the business they needed to conduct so that they could survive. So the United States provided that they could form corporations under federal law so that they could do business and derive income from their business practices. And we'll circle back to that a little bit later as well. The tribes do conduct business. They have 6 for-profit businesses, actually more than that, but there's a holding company here that holds some of the others. And they're quite busy. Mission Valley Power is an electrical utility, a distribution utility that distributes power on the Flathead Indian Reservation. They have 20,000 customers and about $22 million in revenues. S&K Holding Company is a company of several other companies. What they generally do, and I don't understand this completely, but what they generally do is through the Small Business Administration recognition, they contract with other federal agencies and also defense contractors throughout the world, and they provide real-time inventory services for making sure that the Air Force and other branches of the military and military contractors have the hardware they need to do the work they have to do. They also then contract with some other sovereign governments, for instance, the Saudi Arabia and some other Middle Eastern countries. They have facilities there and contract with them as well. S&K Electronics is a high-tech manufacturing facility. It's in Pablo. They manufacture chipboards that primarily used as guidance systems on Department of Defense hardware. Eagle Bank is a local bank on the Flathead Reservation with 1,000 deposits and $23 million in deposits and $11.5 million in loans. And the tribes have 2 gaming facilities. One is the Gray Wolf Peak Casino located near the top of Evero Hill as you go north on Highway 93. And the other is the Quatucknuck Resort. So they're busy in addition to their governmental activities. That's the end of the intro and the context part. Now I'll move into the 5 sections. The first section is really the fundamentals about Indian treaty rights. And if you are working on a river system, generally river systems in the Pacific Northwest, the tribes would assert rights through the eyes of fish because they have treaties that give them the right, give them some special recognition, or they retain special recognition and use rights for fish. To understand how those treaties have power, though, and what their power and force is, you would need to know something about how the treaties were negotiated and how tribes are recognized. So we're going to start with 3 fundamental slides here. The first is about fundamentals with regard to tribal governments. Until 1871, the United States conducted their official business with tribes basically through making treaties. Colonies and states are generally not friendly with tribes, and the entities wind up being pitted against each other because basically they are competing for the same real estate. So they can be natural enemies. So in the period prior to formation of the United States, when tribes dealt with colonies, often they dealt through force back and forth, sometimes through negotiation. But tribes were able to cross back and forth through the landscape, and they didn't really pay attention to boundaries as the colonies had drawn. So colonies had a difficult time because if they were trying to deal with these people that were coming and going through the areas that they were claiming as their colony, it was difficult to do that if they could simply leave. So it was difficult for colonies to negotiate with Indian tribal governments. So early in the history of America, often tribes became more associated with the federal government than they did with the colonies that were here. And that was evidenced at the time of the Revolution because when the United States declared independence in 1776, most of the tribes decided to go with the British at that point because the British were friendlier to them and they knew them better, really, than they knew many of the people in the colonies, particularly the administrators in the colonies. So initially, the federal government in the United States and the Brits, the way they tried to conduct business with tribes was to cut a deal. They wanted to try to keep the peace, and they wanted to try to provide for the colonies to be able to grow and stop any violence between the two. So they cut deals and they tried to keep the Indian people separate from the settling people. That, of course, didn't last because that, of course, didn't work forever because there just got to be too many people with growth of population. So there really were 3 cases that the U.S. Supreme Court first heard. They're referred to as the Marshall Trilogy. They're named after the then Chief Justice, a man named John Marshall. The first one came out of the, I don't know if it was a state or territory at the time, but I think the territory of Illinois. And what happened were some tribal chieftains at that time were trying to convey some land, but they were conveying them to interests other than the United States. So the United States and the territorial authorities in Illinois were pretty concerned about that because they thought the tribes might be introducing a separate sovereign into that jurisdiction. So the United States Supreme Court had formed up at that point in time. This would be 1823. And the United States Supreme Court heard the case. This was the first case where the United States Supreme Court had to weigh up what the rights of tribes were and what the sovereign status of tribes were. So they went to their European history, as they normally would do, to try to determine law, and they concluded that the rights of conqueror would apply in this case, so that the tribes would not be deemed to be fully sovereign because they were completely contained within the boundaries of the United States. But they had not really been conquered. So what the court concluded was that for the purposes of doing two things, one, establishing title to property and being able to sell that title to property, tribes had been divested of that power. And two, with regard to the power of making deals with other sovereign governments, Canada, Britain, Spain, whoever was the problem at the time, they had lost the power to do that as well. The tribes could only purchase and sell land with the United States, and they could only enter into treaties with the United States. The next two cases then both came out of Georgia. Both of them dealt with Cherokee Nation at the time, and the state of Georgia was very aggressively trying to extinguish the Cherokee Nation. In the first case, the tribes were at the Supreme Court, and the Supreme Court had to determine whether or not tribes were foreign governments or whether they were domestic governments. Because if they were foreign governments, the court would have had jurisdiction over a case that they otherwise didn't with some of the domestic nature of the case. When the court went through that case, when they came to conclusion, they determined that the tribes were sovereigns, but that they were not foreign sovereigns. They were domestic sovereigns, and so they had a special class, basically, as a sovereign entity. This became a very important case because what it laid down was that because they were domestic sovereigns, the United States retained a special obligation to protect them from attacks by unfriendly state governments. And it's in essence the foundation for a trust responsibility that's a special relationship between the United States of America and the sovereign Indian tribes found in this country that continues through to today. The third case then was again in Georgia, and it was a follow-on case from the Cherokee Nation case. In Worcester v. Georgia, the court again tried to determine what the rights of tribes were versus the right of the state government. And in that case, the court concluded that even though tribes were domestic dependents, they still were independent political entities, and within the areas that they reserved to themselves, they were governments that could assert jurisdiction, particularly over their intramural matters in those areas, or over any other person that affected their abilities to govern. So you have a fundamental setup here that identifies a couple things if you're going to work on rivers in the West. One is, if you're going to work with Indian interests, you're going to work with Indian tribes. You don't get to work with individuals generally. Now, there might be other property interests that individuals would have, or there might be other special interests that an individual could somehow acquire. But as far as treaty interests or any other ubiquitous interest that's an Indian interest in rivers in the West or fish, you're going to talk to an Indian tribal government. That was the point of me going through that. So if you're going to try to, at some point, figure out what the baseline is that got you there, this is trying to give you a roadmap to find your way back through the law to sort that out. Slide. Then fundamentals with regard to treaties. So tribes weren't states, they weren't foreign governments, but they were sovereign. The method for the United States to work with sovereigns is to negotiate treaties. The Constitution recognizes this, and it recognizes that treaties are the supreme law of the land. It's the first clause. The second then, with regard to treaties, treaties generally don't grant things from one nation to another. Treaties usually are agreements that governments are coming to where they have competing interests, where they're recognizing what they're going to retain and how they're going to work with one another over the things that they retain where they might have overlapping interests. So it's important here to remember that tribes were not being granted anything by the United States when they signed these treaties. They were giving up territory for the right to reserve use rights in that territory and for the right to carve out homelands for themselves where they could continue to practice their ways of living as they always had. So these treaties reserved the rights to tribes. They did not grant the rights to tribes. It turns out to be important when you're talking about fish, because when you're going to measure what a tribe's right of use is, you're going to measure it by their pre-existing use rights from history. It's not going to be based on what their future rights might be in some other state of facts, or what the state might have been willing to grant them, or the United States might have been willing to grant them. Their rights are measured by what they always utilize those resources for. Third, then, tribes are very much favored in courts when you deal with treaties, because a treaty is in essence a contract between two nations, and under rules of contract, the person that drafts the contract is disfavored when you have interpretation that you have to apply. So in this case, the treaties that I'm going to talk about tonight and all the treaties between the United States and tribes were drafted by the United States. So when you get into a court and you look at those treaties, one, the court will look to see, is a contract, you'll try to figure out what the central purpose is. In this case, they'll do the same with treaties. They'll try to promote the treaty's central purpose, which invariably is preservation of the tribes and the resources that the tribes used. Second, they'll construe the treaties as originally understood by the people who weren't drafting them. And in this case, you had people that had a language that was Salish and Kootenai. So they weren't drafting these English-based treaties. So they understood them basically through about a 250-word Salish language that was a negotiating language that a lot of the tribes used throughout the Columbia River Plain. And any ambiguities are going to be resolved in the favor of the Indians because they didn't draft the treaties. So tribes are strongly favored anytime you get into a dispute over treaties. Slide. Here's the guts of it. Within all of the treaties in the Pacific Northwest, there's an Article 3 clause, and the Article 3 clause deals with the right to take fish. I'll do my best on the history lesson. Louisiana Purchase was about 1803. Lewis and Clark did their little adventure in about 1804 to 1806. From about 1810 to 1830 or so, you have Hudson's Bay people running around this part of the planet, and you have some settlers starting to show up, but not a lot. In the 1840s, you start to see Mullen do his thing, David Thompson do his thing, and they start to carve out areas of travel with enough maps that people who want to get out of the east and settle in the west are starting to find their way this way. So there starts to be pressure with settlers coming to this part of the world, and they're encountering tribes, and you have disputes because of that. The Oregon Territory administratively starts to form up in the late 1830s, and then I think becomes recognized as a territory in about 1844, 1845. Don't hold me to the dates, but something like that. So there's a formal place for people to go with laws where they can acquire land, and they can do things like that. But once again, you have states that are really immature in their ability to administer these agreements and immature in their ability to regulate the public health and welfare and peace. And so people that are traveling through the areas are coming into disputes with tribes. So once again, you see the federal government become the vehicle to try to negotiate in a way that will try to keep people apart, the disputing people apart, and will cut a deal. So once again, you see where prior to 1871, the United States came in and they decided to make treaties. So what happened was a young West Point graduate named Isaac Stevens got sent this way. And when he came this way, he had 3 tasks. First was he was named the territorial governor of the Territory of Washington. And that was, I think, probably a political favor. I think Pierce was the president at the time, and he had supported Pierce, so Pierce said, "You're the territorial governor, go." He also then took on a gig where he decided he would be the chief engineer for the United States and laying out the Northern Pacific Railroad line, which turned out to be a lucrative thing for him. And at the same time, by being the territorial governor, he was also chief of the military in the Washington Territory, and he was the chief Indian officer in the Washington Territory. Isaac Stevens was a very intrepid guy. He came out in about 1853. He surveyed the railroad all the way along. And in late 1854, he had done enough work developing the administration of the Territory of Washington that he became very aware of the difficulties that were happening with regard to conflicts between tribal people and non-tribal people. And I don't know when the Whitman Massacre would have been. That was probably in the 1840s, I'm guessing. But there was some violence as well. So it became his task to try to quell the violence and make it safe so people could pass through to get to the Oregon Territory and the Washington Territory to settle. So he went and cut deals. He started the day after Christmas in 1854, and by July 16th, 1855, he had visited with 62 Indian tribes and bands, starting with the Treaty of Point No Point on Puget Sound, and ending up at Council Groves here on July 16th. And I just think that's remarkable when you think of the terrain that guy covered and the number of people he talked to, and he went back and forth a couple times. It wasn't a one-way trip. He went back and forth to the coast several times along the way. This was the 11th treaty that he negotiated. So he negotiated 10 before he got here. 3 of those 62 tribes and bands are in the Treaty of Hellgate, and those are the Upper Pend Oreille, Kootenai, and Salish people that are now part of the Confederation here. All of the treaties have this clause in it. They're all almost identical with the exception of a couple words. The word there where it says places, in some of the Western Washington treaties, that those places are referred to as grounds and stations. But this is really, probably if you don't get anything else tonight, this is really the thing you should focus on. Article 3 of these Pacific Northwest treaties is the foundation of the tribe's rights for everything you hear about with regard to salmon wars in the Columbia River, and everything you hear about here with regard to tribes' rights on restoration of the Clark Fork or fishing disputes or anything else. The particular clause that's most salient is that clause that's highlighted. The tribes reserve to themselves the right of taking fish at all usual and accustomed places in common with the citizens of the territory. Slide. That clause has been extensively litigated and extensively interpreted over time. In particular, the line of cases that deals with fish, most notably in the Pacific Northwest, are two. There's U.S. v. Oregon and U.S. v. Washington. U.S. v. Oregon follows on after U.S. v. Washington, and it largely gets to the same place, just with different tribes. A little different treaty language, but it gets pretty much to the same place. The U.S. v. Washington line of cases would have been intense and heavily disputed and violent in the late 1960s and the early 1970s. Natalie was kind enough to refer to Tanum Creek in my intro. When I was a kid growing up at Tanum Creek, farming there, we were irrigating all the time. There were lots of disputes, and there were Indians on both sides. There was Indians on the south side of that creek and white people on the north, and we had disputes over water often there. I didn't understand them because I was 6, 7, I guess 12, 13 years old, something like that. But it was a topic of conversation, and there were lots of bumper stickers about it. And one of the ones that was most notable was a bumper sticker that went by the tagline of "Can Judge Bolt," meaning can the judge instead of canning salmon. Judge Bolt was a Chicago kid who found his way to Missoula and went to school here. He got his undergraduate degree here, and he got a law degree here, and then went to the Western District of Washington after practicing in Montana for a couple of years, and took on this dispute, which was huge. Because what was happening was the fish runs were declining, the commercial fishing fleets of Western Washington were in distress, and tribes were not able to practice their traditional ways because there were fewer fish for everybody. But tribal members, particularly the Puyallup tribes and other tribes around the southern Puget Sound, were going to continue to fish regardless, because they felt it was their traditional obligation to continue to commune with that species. In so doing, though, they kept coming in conflict with non-native fishermen. And so you wound up with law enforcement showing up, and when law enforcement showed up from state jurisdictions, gee, guess who got disfavored? Indian people did not do well, and people were not interested in hearing about Article 3 of some treaty that was negotiated 100 years ago, or 120 years ago at that time. Eventually, the tribes found their way to court. After a fair bit of violence and lots of criminal charges being brought against them, 6 of the tribes participated in U.S. v. Washington. And in that particular case, the court listened to hundreds of hours of testimony and concluded that prior to ceding their territory to the U.S., that by negotiation the tribes had retained their traditional use rights. And within their traditional use rights, that they had the right to continue to take fish of all species that they took before, and they had the right to take that at their usual and accustomed places. Those rights were perpetual. They didn't end because it was 120 years later. And they had really 2 aspects. When you look at those 2 key clauses of the treaty, the in common with aspect and the usual and accustomed places, you derive 2 things from that. The first is with regard to the in common with clause. The court concluded that because tribes had a right in common with the citizens of the territory, that meant that those 2 entities had to share. And by sharing, they wondered what an equal share was, or what a fair share was. And they concluded that a fair share was an equal share, basically. So the first part they looked at was the fair share aspect. And in phase 1 of that trial, the court concluded that the tribes had the right to take up to half the fish. Up to. They weren't guaranteed the right to take half. They were guaranteed a right to take up to that, but not necessarily half, because the true measure should be what they needed to have a moderate living standard when you looked at their subsistence, ceremonial, and commercial needs. Then the court interpreted the geographic aspect, or the usual and accustomed places language in the treaty. And from that, they concluded a couple things. First, based on earlier decisions, they concluded that tribes had a right to go and take fish and occupy riverbanks to do it. Now, that's been tested again recently because the court concluded that fish meant not just fin fish, but also shellfish. And if you've been in Western Washington, you would recognize that there are a lot of very expensive homes on Hood Canal and areas of Puget Sound. Tribes have the right to go there and continue to fish for both finfish and shellfish, and they have the right to cross through people's compounds to do it. And that was hot in litigation just about 15 years ago because people thought that that should have passed away by now. But once again, the court, in its retained jurisdiction under U.S. v. Washington, concluded that the rights are perpetual and tribes have a right to access the fishery. Now, the court went further, actually, at that point in time, and they identified that the tribes had the equivalent of a servitude to protect the habitat from which the fish arose. That part of the ruling was petitioned to the Ninth Circuit, and the Ninth Circuit, when they looked at that, first ruled in favor and then pulled it back and went to what's referred to as en banc. The entire court looked at it. And after they looked at it, they actually withdrew the ruling. And the tribes didn't oppose that at that point in time because they thought it might be more reach than they could survive legally if the case made its way to the Supreme Court, which they thought it would. So the part of the ruling that identifies that the tribes have a right, in essence an easement, to go and take fish and to occupy riverbanks to conduct fishing activities is still alive and has been blessed by both the Ninth Circuit Court of Appeals and the United States Supreme Court. The part of the ruling that dealt with the tribe's right to protect the habitat from which the fish arose was withdrawn by the court and has never been further litigated except for one small case. And that small case was in Western Washington about 3 years ago, where some Puget Sound tribes sued the State Department of Transportation to try to prevent them from providing perched culverts. Culverts where there's a drop of water between 3 and 10 feet on a highway that stops fish from getting to habitat upstream. They once again asserted that tribes had a right for the State Department of Transportation to change the way they construct culverts so that fish could get to those areas, which is the equivalent of a servitude or some sort of protection right in habitat. So the court has approved that, and tribes are tactically and slowly looking at applying that over time. But that's the only case that's live with that issue right now. I'll stop there. That's a mouthful. Questions on the treaty rights or on fishing rights? Sure.
When you mentioned that tribes are typically strongly favored in these treaties, are you talking about just in like the recent past, or?
Put a time. The question is, if tribes are strongly favored in treaty conflicts, when has that happened? And of course, in the tribes were pretty much technologically disadvantaged from the time whites arrived until the current day. And so, no, they would not have done well in practical disputes. When I'm talking about the advantages or disadvantages, I'm talking about legal disputes in courts. So if they're in a fair forum, as I think, I guess as an attorney, I think forums are supposed to be somewhat fair. If they're in a fair forum like a federal court, I think they're advantaged in a federal court and have been since 1972. Now, there are precursor cases to this. There's cases as early as 1904, which was a U.S. v. Winans case. You'll see cited here in a couple spots, where it's identified that tribes had a right to access rivers. And they did well in those disputes, and the court applied those rules of construction where interpretations were meant to favor tribes. Tribes haven't done as well in state courts, but in Montana courts they've done pretty well, and that's a good segue for this, actually. Anyway, historically, I don't know how to answer that. In courts, they've done well since 1972. Prior to that time, I'm not sure. Sure.
How about the Bighorn River case?
You know, I'm not familiar with it right now. I'm not going to call it up quickly enough to respond.
Didn't do well.
Oh, you're talking about U.S. v. Montana. Yeah, different treaty. Yeah. How about if I circle back to it at the end? That's probably a bigger issue than I can cover in 30 seconds. But yeah, certainly affects tribal jurisdiction today, particularly over non-members. Yeah. Okay, that's the end of part one, and I'm probably way behind on time. So part two. The Confederated Salish and Kootenai tribes have not had a lot of fish disputes here. There have been some bloody disputes with regard to their rights to go and take fish. There was one particular bloody dispute near Placid Lake in the early part of the century. But there are not a lot of disputes that the tribes had with the state over that issue. There were a couple, though. So the one dispute that was really significant here as far as making law was the Clark Fork River claims. As a background to that, under the with regard to the legal basis for the tribes' claims, there's that Article 3 language you see. The tribes, when the Clark Fork River claims were being litigated by the state started their case in 1980. The tribes monitored that case as the state brought it forward. The US EPA filed their suit sometime in the middle 1980s, and the tribes monitored that suit as they went forward. The United States Environmental Protection Agency on Clark Fork River had a responsibility to remediate damages so that they would protect human health and the environment. So under the Superfund law, which is a federal law that provided for the right to the United States, states, and tribes to sue, the federal government's obligation is to protect human health and the environment. It's not to restore the river. They don't have a direct interest in the fish and wildlife. They don't have a direct interest in the land. That passed to the state at the time the state was established by the Enabling Act, or it stayed with the tribes if the tribes reserved that by treaty. So here on Clark Fork, the US EPA went in and basically tried to figure out what do we have to do to protect people in Missoula and people up and down the river corridor, Butte, et cetera, who are negatively affected by hazardous materials. The second part of the law, though, is with regard to restoration. So there's remediation that the EPA does. There's restoration that states and tribes do, because they are trustees for natural resources. On Clark Fork River, the state of Montana started its trustee case, its natural resource damages case, as a trustee in the 1980s. The US started its case in the 80s as well. The tribes monitored both. The tribes thought things were going fairly well until we began to see parts of the state's claim, and we noticed that the state had billed its claim on the fishery, but on the recreational fishery only. The state had not gotten focused on native species of particular importance to tribes like West Slope cutthroat trout and bull trout. All of the state's claims were primarily premised around rainbow trout, brook trout, and other trout that was the focus of the recreational industry. So the tribes became concerned. They looked at their Article 3 language. They identified then whether or not they had a right to try to protect the waters of the Clark Fork River, and they did because they litigated that in a court of claims case that you see there under the second bullet. And then they also wanted to know whether the state was going to push back if the tribes tried to intervene in their case. And they looked at what state courts had said about tribes' participation with regard to protecting their fishery and rivers. And they found that state courts had been very supportive, actually, of the tribe's treaty right and recognized that tribal members who had become subject to prosecution by state fish and game officers for attempting to exercise their fishing and hunting rights protected by Article 3 did well in Montana courts and did not wind up being subject to prosecution. Slide. So then the tribes looked at federal statute. They had the right under treaty to protect Clark Fork River, but they were uncertain whether they had the right under the federal statute to actually get into court. They looked at the federal statute. In this case, it was the Comprehensive Environmental Response, Compensation, and Liability Act, or commonly referred to as CERCLA, or Superfund. The remediation parts of it are Superfund. The restoration parts of it generally don't get referred to as Superfund. But within that law, when it was initially drafted, tribes were an afterthought, and they were not recognized. But the law was amended by the SARA amendments, S-A-R-A, and I can't remember what the acronym stands for. But on the First Amendment in Congress, Congress added language about tribal trusteeship for natural resource damages for trust resources like fish, water, and other creatures in the Clark Fork River. So you see from the language expressly out of CERCLA, there's language there that identifies that tribes essentially stand in equal to states as trustees for damages caused by release of hazardous materials. So in the case of Clark Fork, that's copper, cadmium, lead, and zinc. For releases of those hazardous materials by a potentially responsible party, in this case that was the Anaconda Company that was purchased by ARCO, now BP. For releases of hazardous materials that cause destruction or loss to natural resources. Natural resources are fish. So tribes looked at that case through the view of fish and what had happened to fish. The entity that's been injured is an Indian tribal government. So once again, you see the Indian tribal government is the essential legal form that's going to be recognized under the law. And the agent that can act on behalf of the tribes is the chief or the elected leader. Slide. Putting those two elements of law together then, the CERCLA statute with regard and with the tribes' rights under Hellgate Treaty, in 1994 the tribes moved to intervene. We had hired a woman who had formerly worked with the EPA. She had graduated law school 84 or 94. She got the case going. In about 95, she had serious health problems. I was 16 months in as a lawyer, and tribal council turned to me and said, gee, we've got this case on Clark Fork River. We need somebody to litigate it because our lead litigator can't do it anymore. I was dumb enough and aggressive enough to say, I think I can do that. And so I took the case for them, and we commenced to hire about 5 other attorneys to try to help me so I wouldn't screw it up too badly. And we also started to negotiate intensively with the state of Montana and the US EPA to try to see how we could fit with them to try to add to their case. For instance, tribes, states, and feds are powerful parties when they come together. For instance, there's a clause in CERCLA that identifies that a state cannot proceed to claim for natural resource damages for damages that they basically approved of doing through their state governmental processes. If the state would have, say, done an environmental impact statement and then issued a permit for the Anaconda Company to dispose of waste, which they did, perhaps ARCO would have had a defense to say, we don't have to pay for that. That kind of defense doesn't apply against tribes. So you wind up with a much more comprehensive or seamless prosecution team if tribes wind up on that prosecution team. Now, I don't know if that influenced the United States and the state or not, but eventually the court recognized that we were going to have the right to intervene, and we started to participate with the state and with the United States in talking about the case. Once we had the right to intervene, we started to develop our own evidence. We started to utilize a biometric analysis approach that would have tried to measure the effects of fish on population, production, and diversity through life stages. It would have been something new that maybe would have been very difficult to meet the federal rules of evidence to actually get to court and preserve. But we decided to go that way with something novel and innovative because the state had done something conservative. And we thought we could get both measures then before the court in a way that might be helpful. But before we went very far, the court bifurcated the case, said the state should proceed with its claims for streamside tailings operable unit, the Silverbow Creek area between Butte and Warm Springs Ponds, and they should proceed with that first because it was the most heavily damaged. And they identified that the state should go first with presenting evidence, and we should wait. So the state did that, and once the state ended the first part of their case, or what's called the liability phase, the court then had everybody stop and asked everybody to revisit whether or not they're willing to settle, and then got more assertive and ordered us into some settle negotiations for a while. The parties were successful in those negotiations. We negotiated in 1998. At the end of 98, we came to a joint settlement agreement, and all 3 parties signed it, the United States, state of Montana, and tribes, for one portion of the Clark Fork River settlement. The tribes participated in a small portion of that, and we never got to put on evidence at trial. So for tribes, that's a significant case because the tribes' motion to intervene was granted, and there was federal court recognition that the tribes' Article 3 treaty right in Montana gave them the right to come forward as a natural resource trustee to speak on behalf of fish. Slide. Here's a breakdown of the settlement for that first part. It's not comprehensive. This is about that first settlement for streamside tailings operable unit. The tribes settled their case entirely with this because my client did not have all of the funding and all the resources necessary to maintain the pace of litigation over time. We were coming to a point where I was going to go to them and say, your witness costs are going to be in excess of $100,000 a year, excuse me, in excess of $1 million a year to go forward with this case. And we're going to probably be at it for 4 to 5 years. And they had a lot of difficulty with that, and we also had some other risks with regard to hanging out the treaty language. So we elected to negotiate, and the tribes then also wanted to try to figure out if there was a fair way to measure what they should settle for. And what we did was identify a surrogate resource that was similar in size, scope, and kind to the Silverbow Creek areas that had been damaged. And we looked at the Jocko River Basin on the Flathead Indian Reservation. And the question that I got asked of me is, how can a young Indian person have the same kind of traditional experience if they started walking from the Flathead River, where the Jocko River meets the Flathead, and they walked to the very top of the Jocko Basin up here at the divide line with the Rattlesnake Peaks? What would we have to do to make it so they could have that traditional experience unimpeded by current owners? And so what we did was measure how many lands they would have to acquire so they could walk from the Flathead River to the Jocko Peaks, and what money would be required to do that restoration on the lands that were required so that the properties could be back in a way that would support bull trout and West Slope cutthroat trout. We came to a conclusion of about $20 million would do it. And we got pushed to that number and wound up settling for about $20 million. And importantly, the tribes retained the right to participate in the expenditure of the other $250-odd million that was taken by the state, the United States, with regard to how that money was going to be spent on the upper Clark Fork River off of the reservation. Then the tribes continued to participate at Milltown. I think they were an important voice for dam removal there. And they continue to work with the state with regard to how the state's going to spend its money that it's settled with ARCO for on other units for conducting restoration up and down the river in the usual and accustomed places of the tribes. So that's how that treaty clause came to ground in Montana. Questions? Now, it was much more complicated than that and hard. And my hat's off to the public servants of the United States and the state of Montana. I mean, they did some remarkable things in that case. And I, as a citizen, I'm in their debt. Slide. Third then, out of 5, Federal Power Act would be something, if you're going to work on a river, you would need to know about. Because of the ubiquitous nature of tribes' interests, when hydropower facilities get licensed by the federal government to occupy a river, tribes have an interest in identifying what the environmental mitigation conditions are going to be for that facility and what the operational constraints are going to be on that facility so it doesn't damage the natural resources that exist in the river. So anywhere in the West, if you're working, you should be aware that tribes have rights pursuant to Federal Power Act. Here in particular, I'm going to focus on one project because I think it's a fascinating project and it's the focus of my work right now. Slide. The Kerr Hydroelectric project is located about 6 miles downstream from the Flathead River Bridge at Polson. It regulates the outflow of Flathead Lake. Flathead Lake's a natural lake. Its levels have not changed. It exists between the levels of 2,883 feet above sea level and 2,893 feet above sea level. So there's a 10-foot pool variation. That's the same 10-foot pool variation that occurred naturally. The dam now regulates the outfall, and it's caused a change in the schedule of when that water's released, but not a change in elevation. So the Kerr facility was licensed by the Federal Energy Regulatory Commission in 1930 to Rocky Mountain Power Company, which was a subsidiary of the Montana Power Company. It is an excellent spot for a hydropower facility because there was a cataract or a cleft in the river there that stopped upstream fish passage. So there's no migratory change, really, at least not upstream by construction of this facility. It didn't establish a reservoir, and it didn't change the level of a reservoir. But it has a huge reservoir behind it. And if you're a power person, and you think about the value of a dam, dams are really valuable if they have huge reservoirs behind them because you can ramp power up and down in that dam almost in real time. Power grids need to run like this on a graph, flat. I mean, some of your scientists in here at least. For your power grid to stay stable, you have to have a continual flow of electrons in and out of that alternating current in the system. Wind power and generators and other things run like this. So somebody has to level out those peaks and valleys. That's the best machine to do it, the most efficient, because you can ramp up and down the generators by changing the releases in water in a way that fill in the valleys on that transmission graph so that your system stays stable. So one real value that Montana provides to the Pacific Northwest comes in the form of 2 facilities. Not so much from Kerr anymore, but definitely at Hungry Horse. Hungry Horse has a huge pool behind it, and it stabilizes the Pacific Northwest grid. And if you like wind power places huge demands and huge fluctuations on the system. And these are the machines that stabilize that out. And this plus some gas. So it's an important facility that way, and when Montana Power Company built it, it was their peaking facility. That's one of the reasons they built it that way. It basically took care of those peaks and valleys in Montana Power Company's grid so that they could have a stable system. So anyway, it's a great spot to build a hydropower dam if you want to build hydropower dams. It's a big dam. It's a concrete arch dam, which makes it a particularly good dam because it's stable against earthquakes. It's got 3 powerhouses and 3 tunnels that lead to the powerhouses. On this slide, Polson's upstream, of course. So Flathead River goes right and then back left hard to the bridge by Polson. It's got 14 radial gates that come down to let the water flow over. There are 3 tunnels that come through right here. The tunnels run about 800 feet and they drop about 180 feet. That's a lot of head for a dam. So they run right through this isthmus of land that this photographer is standing on, and they go through 3 powerhouses where 3 turbines spin, basically by capturing the energy of the water, that spin 3 generators. Slide. It's also helpful with the 2 dams being high up the system, and this is an interesting graph, I think. It's a graph of the Columbia River Basin power facilities. But rather than being a plan view, an overhead view, excuse me, I'm going to get that wrong. This is a plan view, right? Is there an architect in the house? Rather than being an overhead view, it's a side view, to try to give you some sense on elevation on which dams are higher up the system. So these are all the dams in the Columbia River system, including the Canadian dams. Kerr is not quite the highest. Hungry Horse is the highest up the system. That turns out to be an important thing because one of the functions it also provides is flood protection. And one of the economic benefits that comes from flood protection under the complexities of the Columbia River Treaty are that dams upstream get paid headwaters benefits from dams downstream when they provide storage services. So another good thing for Montana is that storage services are paid for these facilities because we're so high up the system. Anyway, it's esoteric, I guess, but interesting. Slide. With regard to Kerr, the company took a license from the Federal Energy Regulatory Commission, or I guess Federal Power Commission it was named at that time, in 1930. Started constructing in 34, it went operational in 1939. They put in 1 turbine to start with, and they built the other 2 later. Licenses are routinely issued for 50-year terms. In the first 50-year term, there was no environmental mitigation conditions whatsoever and built into that license. The company ran it to generate power and make money. The tribes received a land rental charge because the company operated the bed and banks of their river, but they didn't receive any compensation for the damages to their trust resources in the form of fish kills, wildlife kills, and most notably, varial zone habitat destruction. When you think of dams releasing water, you might think that water goes up and down. The real damage is side to side. As that water goes up and down, the river varial zone changes significantly, and that zone cannot sustain life as it's wetted and dried, particularly in the most intense seasons of winter and the hottest times in summer. So that varial zone, which should have been one of the richest biological areas to the tribes, was really lost to them. And they hadn't been compensated for it for 50 years. The license came up for reissuance in 1980. The tribes decided to compete and see if they could take the license away from Montana Power Company and take over the facility. So they submitted a competing application to the FERC, and in that competing application, they identified that there were going to be some pretty serious environmental mitigation conditions applied against the company, which of course would change the operations of the dam. It would take away some of that peaking capability that's so good for leveling out your system, but so destructive to rivers, so that the tribes could protect their fish resources. The tribes didn't really have a monetary interest in this facility because they didn't participate in the profits or any of the sales. But they were certainly participating in the injuries that were occurring to their resources. So they worked with the Department of Interior to go back through the Federal Power Act and identify what the environmental mitigations should be, the environmental mitigation conditions should be. One of them was to take the facility away from being a peaking facility and making it a baseload facility, so that that varial zone would stop shifting within hour and within day, and that you would develop a hydrograph through the year that would resemble the natural flow of the Flathead River more closely. And the tribes prevailed in that. They also required the company to make payments so that the tribes could acquire habitat to compensate for the lost habitat due to the varial zone damages that still existed. And they received payments to do restoration work within the habitat that they acquired. When the company looked at that with the new economics, with these mitigation requirements, and with the dam being baseload instead of peaking, and at that point in time the company had some cash flow issues, they were willing to negotiate with the tribes on the license to a settlement rather than to continue to compete and risk the potential to lose the license in the 1980s. The tribes stepped back from claims that they were making for the company what the land rental charge should be, and the company said, if you're willing to do that, what we'll do is split this license with you. We'll take the license for the first 30 years, At the end of that 30-year term, you can buy the facility from us and then it can become yours. The tribes wanted to do that. The end of that 30-year period is in 2015, and the tribes are preparing now to acquire this facility. We're in a dispute with the now owner of the facility, PPL Montana. They're the successor in interest to Montana Power Company. And the tribes are preparing to acquire this facility. So soon my client is going to become much more textured. They're going to become a sovereign government with a treaty right and a trustee's interest in fish and wildlife. And they're going to become a generating utility with a merchant product that they want to take to market. And it's going to be very interesting for me to try to figure out how they want to balance those competing interests. Slide. The dam itself is it's relatively small by Columbia River standards. It generates 188 megawatts, which is a lot of power if you go through this. You'll see that it generates 188 megawatts, but it can't do it at 100% efficiency. You can't run all 3 turbines all the time because, as you know, our water runs off at uneven rates through the year and through the day sometimes here. So it operates at about 66% efficiency. When you take that 66% efficiency and you apply it against the hours of the year, you find that 188 megawatts times 66% efficiency times 8,760 hours in a year generates about 1.1 million megawatts on average per year. Now that's a lot of power because a megawatt can serve about 750 households. And when you do that math, you see that Kerr can provide the power for about 94,000 households. Big. But when you think about Grand Coulee, Kerr's nameplate rated at 188, Grand Coulee's nameplate rated at 7,000. So what's big depends upon your perceptions, I guess. At the highest day of runoff last spring for Kerr, it was running at about 56,000 cubic feet per second water. The Dalles was running at 560,000. So we're big and we have important facilities, but it gets bigger as you go downstream. Slide. If you look at the economics on the Kerr, if you think back to the first slide, the tribe's budget for the year is about $105 million. This is a very important facility to them. Right now they're getting a land rental charge that's about $18 million a year. If you do the economics on what the power is worth out of this facility though, if it produces about 1.1 million megawatt hours in an average year, an average price of power over the last 10 years has been about $50 a megawatt hour. It's low right now, it's down in the 20s actually, so we're in a low peak. But an average value is about $50 a megawatt hour. You multiply that against 1.1 million megawatt hours, you come out with a gross revenue flow of about $55 million a year off the Kerr facility. For an Indian tribal government that's been living on $17 to $18 million a year, to try to fund a budget of $105 million and find other ways to fill in that gap, this is huge. This is half the cost of their government. It's a very efficient facility to run. It costs about $8 million to run it. So they're going to have a net revenue out of that of about $47 million. They get a current rental charge of about $18 million. So the difference or the increase that they're going to accrue if they take over the facility is $29 million. I expect they're going to do it. So part of the message here is not to try to say, gee, know how to do economics for hydropower. Indian tribal interests in rivers are changing. Tribes are changing. Gaming really propelled tribal governments in the East and in the Midwest in ways where they became economic engines for their people. And the expectations of the tribal membership changed. And they expected their governments to become economic engines. In the West, there are 2 tribes now that will have FERC licenses. One is the Warm Spring Tribes of Oregon with the Pelton and Round Butte projects, and the second are the Confederated Salish and Kootenai tribes. Beyond that, the Navajo are very active in coal mining and energy generation with that. And the northern and southern Ute tribes in Utah are very active with gas development, gas gathering, and gas transmission. So tribes are changing and they're very much participating in the energy arena. Slide. Questions on that? Sure.
It seems like, from your description, that the Indian tribes greatly benefited with hindsight. During the period of that hindsight, there were technological advances, scientific advances, better understanding of stream flows and things like that. Nowhere have you indicated any bad faith on the part of the people that built it. Do they get some benefit of that hindsight boost that the Indian tribes get because of that.
Who's they in your question?
The people over there.
The company.
Yeah.
So the question is, the tribes are perhaps benefiting from the development of these technologies and the development of the infrastructure over time, and by waiting, maybe it's an appropriate time for them to take it. And the question is, do the people that developed it, are they going to receive some benefit prospectively into the future?
Count when you're figuring out the proportionate cost.
Well, right now, the licensee is PPL Montana, which is a corporation out of Pennsylvania. And they're the ones that are receiving the benefit of selling that power. My client's getting $18 million, and they're taking home whatever they get out of their sales. So financially, they're certainly benefiting now. Will they benefit in the future? Interesting question. Within the license, when the tribes negotiated to acquire the facility, there was a calculation set up for what the purchase price is supposed to be. We have a disagreement about that. They think, of course, the price should be higher than my client thinks it should be. And it's a substantial disagreement. Public record identifies they think the facility should be worth $55.4 million. We don't think it should be that much. So I guess it's a question as to whether they will profit in the future from the sale, as to how we do with that dispute. Do they benefit in any other ways? Certainly we all benefit from, I think, the tribe's focus on protecting treaty trust resources and rivers over time. So we all have that societal benefit from the ecological health that tribes have stayed focused on. Beyond that, I don't know that the companies have benefited exactly. We're certainly negotiating with them, and as the tribes become business entities, or a business entity as a retail or as a wholesale generator, we want to work with them, and so we're talking with Northwestern Energy. I have a meeting with them next week. We talk with PPL Montana and their Energy Plus marketing arm all the time. We talk to Avista, Bonneville. We're talking to a lot of people.
Does this subject come up in your negotiations?
Does what subject come up?
That's why we talked about the hindsight aspect of improving technology and science during a 40 or 50 year period of time.
Oh, yes. Yeah. Yeah, I think people, well, you know, lawyers argue what advantages them, basically. So I'll argue historic injury to my client. But we, well, but now we're at a point where we need to forge alliances with people to make this work, to be in business. So certainly we try to have credibility with them and identify ways that they have done good things for the tribe and ways that we perhaps can do good things for both in the future. That's kind of a diplomatic answer, but I'll be happy to talk with you afterwards and maybe put some more detail to it. Okay. Natalie, when do you need me to stop? Cold. Because I'd do the Columbia River Treaty and probably do it in about 10 minutes and be done at 20 after.
Okay, yeah, that was still leaves a
Keep going.
few more minutes for questions, as long as we have a few minutes at the end.
Okay.
Okay.
All right.
I think I was originally invited to talk about Columbia River Treaty, so I better get to this, I suppose. This is one of the topics I know less about because I'm just really getting introduced to it here over the last couple months. Let's take a slide. The Columbia River Treaty, if you know the geography, originates in at least, well, the Columbia River Treaty has two major arms of it. There's the Columbia arm and the Kootenai arm. The Columbia, so Pacific Ocean, Columbia River, lower Columbia River below the Snake, mid Columbia between the Snake and Grand Coulee Dam, and then upper Columbia above Grand Coulee Dam. There are two arms of the Columbia above the Grand Coulee Dam. The first is the Columbia arm that goes up north into Canada. The second is the Kootenai River arm that crosses through parts of BC, circles, and then comes back into the United States. Well, actually, I'm going the wrong way. Comes out of Canada into the United States and then goes back into Canada. There's also areas of the Flathead and Clark Fork River that go to Lake Pend Oreille, and then in the Pend Oreille River go into Canada. So you get this river crossing the boundary both ways. The parties needed to deal with that, and so in 1909 they cut what's called the Boundary Waters Treaty. And the Boundary Waters Treaty basically says there's going to be a commission. The commission is going to deal with injuries that occur to people downstream. The people downstream have the right to go to the host nation that caused the injury and sue them using the law of the host nation that created the injury. So if somebody dammed the river upstream from the boundary and it dried up the guy downstream, you could go into Canada and sue in the courts in Canada, basically. But more so what it said was this International Joint Commission, IJC, will be the negotiating point that will take care of it so that we don't have these kinds of disputes. Well, that worked for a while, and then in 1948 there was a big water year, and all of Vancouver and Portland got flooded with significant amount of damage. After 1948, from then until about 1961, those are the go-go years for dam building. So everybody thought the solutions for hydropower issues were to build more dams. And there was lots of population growth in the Pacific Northwest, so people wanted to build dams to generate hydropower. So with those things conspiring together, in 1961, Canada and the United States negotiated a treaty referred to as the Columbia River Treaty. The Columbia River Treaty allowed Canada to construct 3 dams, actually mandated that they would do it, and it allowed the United States to construct 1. The 3 dams in Canada, let's see, let me step back. Probably getting off slide here a little bit. The dams are particularly important because the Columbia Basin has a lot of variety in it. It's seasonal, and it's seasonal in a way that eastern rivers aren't really. Because of the Rocky Mountain effect here on capturing snow, we get a wide variation in the amount of flow that goes down the system between seasons. We also get a wide variation between years, much wider than you see on the Missouri or the Mississippi. So the entities thought the solution to that would be to provide more storage behind dams so that they could regulate releases and protect Portland and Vancouver, and also release the waters that were stored in ways that could have a cascading effect downstream with regard to generation of hydropower. So let's go back one slide, please. So in 1961, the US and Canada enter into a treaty. The parties need 3 years to figure out how they're going to implement it. So it gets ratified by the Senate in 1964, and the parties figure out how they're going to go forward with it. So it starts to be implemented in 1964. And it does 2 things. For a 50-year period, it provides that the United States is going to have a right of flood control from Canada. And this is a mistake. The power entitlement's not 50 years, so scratch that. The right of flood control is the United States purchased the right for 8.5 million acre-feet of flood control in Canadian reservoirs, in newly constructed Canadian reservoirs, so that they could protect Portland and Vancouver from flooding by holding back that 8.5 million feet in times when the United States needed the protection. Slide. Slide. So Canada constructed 3 large dams, Mica, Arrow, and Duncan. Mica and Arrow are on the Columbia River arm. Duncan is on the Kootenai River arm. They have a total storage capacity of 15.5 million acre-feet. The US took a right that Canada would hold back 8.5 million acre-feet and protect Portland and Vancouver with that. And Canada took an obligation to release the entire 15.5 million acre-feet each year in ways that would benefit both Canada and the US with regard to generating hydropower. The first requirement for holding back the 8.5 million feet, Canada didn't want to get into a perpetual requirement for that. So they said, we'll do that if you pay us half the amount that you think you're going to avoid in injuries by floods. The United States said okay and paid Canada $64 million. In return, they got a right of storage, automatic storage of 8.5 million feet in those Canadian reservoirs every year. And we've used it often. Then the Canadians said, well, we're also going to have this 15.5 million acre-feet total of water. If we release that in a better scheduled way so it benefits both of us, how about if we share the economic benefits from that? The United States said yes. So in good years, that turns out to be about $700 million worth of enhanced power generation. In not so good years, it's about $500 million, and they split that. So that use of power, which is primarily in the United States, results in a sale of power here that favors Canada to the effect of between $250 to $350 million a year. The treaty continued in force and effect from 1964 until 2024. And the parties can choose to keep it going, at least with regard to the power entitlement part, or terminate it, or amend it. But whichever they're going to do, they have to give 10 years notice to the other entity when they're going to do it. So this treaty could be terminated, or the parties could identify they want to continue with it. or they could ask for amendment starting in 2014, 10 years prior to the termination date of 2024. The two biggest things in play then are this flood control, the 8.5 million acre feet of flood control in Canada, which we've already paid for, which will terminate in 2024. If the treaty goes forward without change, that'll just terminate and we won't have a right to that flood control anymore, at least not an automatic right to it. And the power entitlement will continue and the US will keep paying $350 million back to Canada each year. So the parties are now trying to measure up with the change in economy over the time, with the better ability to manage river systems because of better modeling capabilities and more understanding of science. The US is trying to figure out, is it still worth it for the United States to stay in this agreement? Or should we get out of it? The Canadians are doing the same thing. The entities that are doing it on the US side are the Bonneville Power Administration and the US Army Corps of Engineers, because they are deemed as the, quote, US entity for representing the US on the treaty. On the Canadian side, it's BC Hydro, the BC provincial government's corporation that manages their hydro facilities. Slide. Slide. Let's go to, I've screwed it up, haven't I? I've been talking about this. Okay. Yeah, let's go there. So the question then is whether we should stay in the treaty, because if we choose to stay in the treaty, we're going to have to continue to pay Canada half the value of the power enhancement that comes from having built those dams, about $350 million a year. Right now, the U.S. is engaged in studies to try to figure out whether that's in fact the case, that it's worth it to the United States to do that or not. Slide. The flood control provisions are interesting and they affect Montana. The U.S. bought the right to have 8.5 million acre feet held in Canadian reservoirs every year. If we go forward, we'll no longer have that right automatically, but Canada has an obligation to provide the right if the United States calls upon them for it. So the U.S. has the right for called upon flood control, but if we call upon Canada for it, we have to pay for it. And the amount that we'll have to pay is still uncertain at this point. The parties need to sort through that. So the U.S. is weighing up that issue, and they've gone through what's referred to as a phase 1 study. BPA and the Corps have gone through that phase 1 study to try to identify whether or not the flood control is worth it to Portland. Is it worth it to protect Portland Airport and the areas in the floodplain in Portland, or not? And have we gotten good enough at generation, and do the Canadian releases come at times of years that are lucrative enough for our generation that we no longer want to share the power entitlement? If that's the case, that the U.S. thinks we don't need the flood protection, and we're going to get about equal generation out of the water one way or the other, then it's probably in the best interest of the U.S. to terminate the treaty, or amend it, or try to negotiate a new one. So that's the game that's going on with the Canadian River Treaty, or excuse me, Columbia River Treaty. Slide. So if the treaty continues, there'll be coordinated planning. We'll continue to pay for the Canadian entitlement, and we'll have the right to call upon flood control, but not the automatic right. If the treaty is terminated, we don't have to pay the $350 million anymore, but we will have to pay for any called upon flood control services we get. And if the treaty is amended, it'll just be something new. Now, the called upon part is important to the U.S. because if the treaty continues, but we don't negotiate for a continued right to automatic flood control in Canadian reservoirs, the Canadians only have to provide called upon flood services after we make all effective use, are the terms, of American reservoirs. No one knows what effective use of American reservoirs means. Perhaps that means holding our reservoirs higher at periods of time that might result in environmental damages that might be things that are now precluded by Endangered Species Act protections to endangered fish. Perhaps that means we would have to operate our reservoirs in ways that are not economically advantageous for us for hydropower generation. That's the thing that will affect Montana, because there are 3 reservoirs that are system reservoirs that will be affected by this change to effective use. The first is Kootenai Reservoir behind Libby. The second is Hungry Horse Reservoir behind Hungry Horse Dam. And the third is Flathead Lake behind Kerr Dam. So that's the local effect. What does effective use mean? And what effect is that going to have on our ability to control releases from our own reservoirs? And what effect is it going to have on our ability to generate power? Slide. Tribes have interest. There are 15 tribes that have direct interest in the Columbia River, generally by treaty, a few of those by executive order. You see where their reserves are located and where their offices are. Slide. The 15 tribes are listed on the left. The tribes have organized themselves into 5 groups. Going from the upper basin to the lower, the Confederated Salish and Kootenai tribes are self-represented. We're the only tribe that's set up in a way where the flows that leave us go to Canada before they re-enter the United States. We're also the only tribe out of this list that doesn't have anadromous fish, ocean-going fish, that somehow comes to its reservation. We've been cut off from that, obviously, by Grand Coulee Dam and by geography as it was before anyway. Most of the ocean-going fish didn't make it past Albany Falls at Lake Pend Oreille. None of them did. So we have somewhat different issues. We're also becoming a wholesale generating utility. So we might have a different look or a different perspective on what the right method or the right way to operate the Kerr facility is, for instance, than other tribes might see that. It'll be interesting to see how that plays out. Then there are 4 tribes that are the Upper Columbia United Tribes. They are, I can't read that from here, it's a tough color, but oh, I got this wrong. I got the wrong tribes with the wrong entity. Yeah, I flip-flopped these. These are the Upper Columbia United Tribes for the area between the Snake River and Grand Coulee Dam. So Coeur d'Alene Tribe, the Colville, Kalispell, Kootenai, and Spokane's, they're actually the UCUTs, the Upper Columbia United Tribes. So these need to be flip-flopped, these 2 representatives. These tribes are all Snake River tribes, and they've organized themselves into a group called the Upper Snake River Tribes. And the Columbia River Intertribal Fish Commission are the tribes that have interest between the Snake and Bonneville Dam. And so those are the tribes at Umatilla, Yakima, and Warm Springs in Oregon. And the Cowlitz then is unique because they're below the last dam. And they're the only tribe that's below the dam, and they're more ocean focused because they're in the estuary for the Columbia River. So you have 2 tribes that are self-represented on the upper and lower end of the Columbia River, and the other 13 tribes with direct interest have formed up groups to represent themselves in Columbia River Treaty. Slide. Their concerns are, as you would think. If you think of Article 3 in the treaty and that they're sovereigns, they're concerned because the treaty was negotiated before tribes really were effective governments with regard to having significant infrastructure so that they could participate in negotiations. So the Columbia River Treaty was negotiated without the tribe's unique legal and treaty interests really taken into account. The treaty was negotiated about flood control and power. It wasn't negotiated about ecological services or ecological function. And the tribes are concerned about that. It also does not consider tribal cultural values. Particularly if you look back at U.S. v. Washington, you see that some of those, some of the shared, I'm going to forget the right word, the subsistence, commercial, and ceremonial uses. Yeah, those uses are cultural uses, particularly the spiritual and subsistence uses. Those were not taken into account when this treaty was drafted. And it created a system that degrades the rivers from the tribe's perspective, at least with regard to their treaty fishing rights and from a fisheye view. It affects tribal economies, particularly their ability to harvest fish and sell fish. And the tribes were not participatory. And they don't participate in determining what the headwaters benefits are going to be, and they don't participate in any economic benefits. Slide. From that, the tribes develop a common view document. I think this is actually a store. I think this is the first time the 15 Columbia River tribes have ever gotten together and issued one document that they all co-signed, having to do with river operations. So it's a fairly historic thing. They all have treaties that have very similar language, but they've never all gotten together before to issue one message. In this circumstance they have. They said that their sovereignty has to be respected, that their cultural and natural resources have to be included in river management, and they can't simply be ignored. It has to result in healthy and usable fish, wildlife, and plant communities so they can continue their subsistence uses that are guaranteed to them by treaty and recognized by federal courts. It has to integrate their cultural and natural resource expertise, particularly because they've developed the capability in the current age to do that. And it has to provide some sort of equitable benefit to the tribes with regard to their sovereign rights. It has to protect and preserve the benefits of their settlement agreements with Bonneville Power Administration. Something I didn't talk about tonight, but is a whole other area of tribal participation, is on Columbia River pursuant to the Endangered Species Act and biological opinions. There are 4 tribes that have fish accords with Bonneville where they're going to receive fish mitigation money equal to $1 billion over 10 years. That's billion with a B. So the tribes wanted to make sure that those agreements for the mitigation work they're doing were protected. The tribes wanted to get some recognition for their flood control benefits. Preservation of habitat and protecting the usual and custom places that tribes have done provides ecological services so that the river doesn't release its water as quickly as it otherwise would have if the rivers were dredged and the wetlands and those things don't exist. Tribes think they should be given some benefit for having exercised their treaty rights to protect those. And lastly, the tribal reserved rights for future ecosystem-based management and also other beneficial uses, i.e. perhaps Kerr, or changing interests that tribes have in the river, need to be protected. That's the tribe's position. On the paper you got there, you have the actual Common Views document that the tribes generated, so you got the full text of it from the actual press release. Last item, the 5th one's about Indian water rights. I'm going to stop because I don't know this that well, and it's pretty straightforward. If you have any questions about it, call me. I'll be happy to talk with you about it. If you're working in western waters, particularly in Montana, this is important to know because these rights are unadjudicated in the waters of western Montana. No one knows yet, pursuant to a binding court decree, what these rights are. They're being negotiated right now between the state of Montana and tribes, and they're probably going to change the amount of water that's in the river. It's my story. I'm sticking to it.
We got time for one question. So somebody with a zinger, please.
Sure. Relevant to the Supreme Court case that is being examined on the rental of the riverbeds for hydroelectric.
The Montana Supreme Court case with regard to bed and banks rental.
Yeah, we're just going to the U.S. Supreme Court.
It's been heard by the U.S. Supreme Court, yeah, and they're working on an opinion now.
The tribes are watching that.
Sorry?
The tribes are watching that.
Salish and Kootenai tribes? Yes. When a license gets issued for a FERC facility, the United States has the right to issue that license because there's a commerce clause in the Constitution that says they regulate commerce amongst the states, and they retain the right to assure that rivers are navigable. So in the 1920s, when Congress was trying to figure out what are we going to do with this mishmash of hydropower dams that's showing up all over the place, we can't have the Secretary of Agriculture issuing a license in Forest Service ground, somebody else doing it in Indian ground, yada, yada. Let's form the Federal Power Commission. So they do that. Federal Power Commission, now the FERC, the Federal Energy Regulatory Commission, issues a license. It authorizes a company to place a hydropower facility in a river. But when the states became states, they were granted title to the bed and banks of rivers by the United States. So states hadn't sought rental charges for those occupancy of the bed and banks by licensees. Montana did that. They got forced to do it by some people who were on school board in Bozeman, basically, and the state finally took on the case. So far, the states prevailed through the state courts. The FERC licensees have, in essence, either settled or failed with their challenges all the way through Montana courts. And finally, PPL Montana, the last defendant standing in that case, petitioned that U.S. Supreme Court. That ruling's coming. Now, are we watching? Yes, we're watching, because the Kerr project includes the reservoir that's Flathead Lake. Half of that's on the reservation, half of it's off the reservation. Title of half of it belongs to the tribes, title of half of it doesn't. We might have to pay a rental charge to the state if the state attempted to claim that from the tribes. Is that responsive? Okay.